can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness turns tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tuning every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces turn stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious, make Sylvia spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey, good people. Hold on a second. Hold on. I got to move this chair here because that chair looked like a very awkward spot here. That's my little messed up chair. I got to push it over because it's kind of like awkward. All right, guys, because it's hiding my little vision board thing back there. I'm sorry. Hey, everybody. Welcome to the infamous channel. I am here to give you guys some update on what happened today at the hearing. You guys know I was at two particular cases that I'm working on. They had hearings and neither one of them took place, but I can tell you what happened in the courtroom regarding this, okay? We're going to, because Gregory King's a little bit longer, so we're going to do that one second. What I'm going to do is talk to you regarding the first individual, Marcus Crawford. He had a hearing supposed to have been at 10 o'clock today, but that hearing did not take place. And the reason for that is they have decided to merge the cases together, and on March 12th, they will be back to do a pre-indictment on his case along with the other individuals, status hearing and pre-indictment hearing. Okay. I know you guys have heard that his case was dropped. That is not the case. It was not dropped, and the reason for that is they, when they do a null process, they can rearrest a person and redo it because at the time they did not have enough to continue the case, and cases on the calendar for a certain amount of time, and if it's not worked on, they have to redo it. I don't know what it's called, but it's a process where they I don't know what the term is called. I know someone who's maybe an attorney, and they can tell us what is exactly what it's called, but they can call that case back up. The only way they can't call the case back up if it's dismissed with prejudice. That's when they can't bring anything back up against you. So anytime they just drop some or let it go, that means they can come back and get you afterwards. Okay, unless it's a well, it's not a reindictment because they never indicted it, so it's not a reindictment. It might be a recharge because they never indicted him yet. They didn't indict him. They don't get an indictment until you get an indictment number. So they can come back. Let's just say they can come back and get them. Let's just put it in layman's term. They can come back and get them. So on the 12th of March, all 7 individuals will be in court to do a pre-indictment hearing. Okay? They will all be there. Okay? Right now, their case have not been indicted. It has a PI number, pre-indictment number right now currently. And the pre-indictment number, I wrote it down and it's not in here. CMT, do you happen to have the pre-indictment number? We can give that to the people. I think, let's see. She might have that information for me. You got that information for me? My darling? Okay, the pre-indictment number. Well, not that y'all gonna look it up anyway, so I don't need to Okay, that's the number right now. This is the current number that they have for the case. It's 25 PI, which means pre-indictment 000367. Thank you, CMT, for that. So that is what's happening on that case right now. It's still in the investigations phase, and it has not been worked on. And in the other case that supposedly was dropped, which was a theft type of thing, they a theft type of thing, it has not been dropped. It just merging it with the other cases. Okay, now I wanted to get some things corrected. I know there is a rumor flying around on the internet regarding Mr. Williams' international immunity. It's not true, y'all. Not true. Not true at all. I don't know where somebody's getting that from. Maybe they got confused with the immunity that Mr. Steele putting in for Mr. Gregory King, but that has nothing to do with Jeffrey Williams. Okay, that immunity had nothing to do with him. It's an immunity for his brother's case, and that has to do with protection of property, and nothing to do with international travel or anything like that. Okay, now let's talk about what happened today in regard to his hearing. Okay, I met Judge Williams. Judge Williams seems to be a very fair judge. I've sat in the courtroom and watched her do some of her work in regarding to one of the cases she had in there, a case having to do with a plea deal. Okay, this guy, he had stolen about $33,000 worth of item. He broke into a person's house and robbed them and stole some item. It wasn't aggravated assault or anything like that. It was that he he went to burglary, robbery. So he went and took the jury items, and he took it to the pawn shop. This is another case. He took it to the pawn shop, and upon him pawning the items, it was $33,000 worth of jury. Most of the jury was received back, but not all of it. So the state was requesting a certain amount of time, and the defense wanted a different amount of time. So he ended up getting 2 years, a total of 3 years, but a time commuted, and the judge told him if he performed take the class for theft, if he take it within 30 days, his probation stuff would be thrown out, would be dropped out. So she gave him time served, and he didn't have to serve any time, because she saw his history, and his history was that the last time he's done anything was back in 2014, that he was arrested for and convicted. And so since then, he has changed his life around, and he has helped his family and things like that. But what happened is somebody dropped the ball, where it was a warrant out from a long time ago, and nobody did anything. And then he was in Rockdale County, and Rockdale arrested him because there was an old warrant out, an old warrant that was never handled. And he says he didn't know that the warrant that was out. But anyway, what I'm saying all of this for is because Judge Williams seemed extremely fair, from what I watched her case. But I can tell you right now, her staff sucks. Because some of them didn't even know what certain things was. So I was like, maybe that is why there's that 15 charges of things not being done, because her staff is not bringing it to her. Because the judge don't do the work. All the judge do is basically sign off on it. We may read the charges and things like that that's given to her, but most of the legwork is done by her staff, or whoever's supposed to be doing. And I'm gonna tell you right now, her staff's not too good at all. Not too good at all. They seem very disorganized. Can I say disorganized? Y'all? And they're making her look bad. They're making her look real bad. You know what I'm saying? Real bad. They're making her work harder. If you don't have a great team doing the stuff for you, you're going to be the one that looks terrible. Just like when stuff happens in the chat, it reflects on me, right? It reflects on me, not the people that's in the chat. So you have to have some good people behind you. And I don't think her staff is good enough. I think they're kind of lackadaisy. They tend to be a little bit discombobulated. Yeah. Discombobulated. That's what I think. Right. So I just hope everything works out for her. But she's a little witty, and I'm going to explain to you exactly why I said what I said. Okay. Now, when it came to Mr. Gregory case, we heard her do the call for her calendar, and she only mentioned 3 individuals' name, and we did not hear anything about Gregory King. So then she asked everyone who didn't hear their name, and if they had a case there, to stand up and just let her know the name, and she'll give them information on it. So one of Mr. Gregory's siblings stood up and asked the judge if they had called him. So the judge basically mentioned to her that that she needed to contact Mr. Steele because that particular case was not to be called on the calendar today, right? So we all left the courtroom because they said they weren't going to call. I went downstairs because I was going to go and check out the 4PF people, right? On my way in the hallway, I happened to see Mr. Steele, right? And when I saw Mr. Steele, I said, Mr. Steele, they didn't call your client. And Mr. Steele said, well, he's going up there right now. And so he asked me if I want to come along. I said, sure. So I went right back upstairs to Judge William. This is what I'm talking about because she already said there were certain things, and now Mr. Steele didn't even know either. He didn't know that the case was already was not supposed to be on the calendar because according to him, he had not heard anything, and that's why he was there to to show up for his case. So we went back up to the courtroom. Mr. Steele went up, and so Mr. Shard was there, and so the judge asked Mr. Shard, "Do we have a case for you here today?" And he was like, "No." So she's like, I didn't think so. So then she said, "Oh, we have the." Yeah, she made a joke. It was like basically Mr. Steele, right? And Mr. Steele went up and he went over to the podium and he mentioned about his client having two motions that are outstanding, and so she told him that he wasn't supposed to be there, and I don't think Mr. Steele got that message. This is why I was telling you about how her staff is not up to par and provide information and getting things out. Well, Mr. Steele did not get the information about his case not being done today. So she goes and she tells him that during the time when he was in New Brunswick, they brought his client out, right? And at that point, it came to her attention that his client was hearing impaired, that he was not able to hear. And so she said that what she did is she wrote everything down on a piece of paper and gave it to him for him to read. And so once he read it, she wanted to make sure he understood what she was writing. And so she said she knew a little bit about some sign language, and so she asked him to give a thumbs up. I guess she must have wrote it in the note thing. She told him to give her a thumbs up if he understood exactly what she was saying. So she confirmed. She said she wanted to put it on record. She confirmed to him that to Mr. Steele that his client understood what he was saying. So he gave her a thumbs up, right? So the judge did apologize to Mr. Steele if he did not get the message about his client, understanding, and his client wasn't supposed to be on the record. Now, what she did, you guys remember the other day I showed you guys the calendar. Her calendar stands from, because I thought it was the whole time frame that the trial was going to last. It was specifically for him. No, her calendar that I showed you guys, where it said from March 3rd to April 27th, that is for all the cases that she had on her calendar that's supposed to be going to trial. She put all of them on there, and every single one of them is not coming in at the same time. They all come at different time. It depends. If some is taking plea deal, she's just going to handle the plea deals and then continue working on. So she says the only thing she has left right now to work on is murders, rapes, and something else. She said the high cases. The high cases where she can't just give a bond but she has to actually work it, and it has to be some sort of agreement or something else. But she did all the other small stuff like the petty theft and robbery and all those things. Anything that doesn't have anything to do with aggravated assault, those were done earlier. Okay, so the date that shown on her calendar from the 3rd to the 27th of April, 3rd of March and 27th of April, are just cases that needs to be worked on, or the ones I mentioned about the theft. I mean the murders and all this kind of stuff. Right. So she told Mr. Steele that his client understood everything she said, and also that um, he has a special date, right? So Mr. Steele reminded her about the two outstanding motions. And she says that one of those, she thought it was supposed to be on Wednesday, but then the person that's in her staff said, no, it's not Wednesday, it's for the other ones. And they were like going back and forth, having a discussion about this. And like I told you, they don't know, one hand don't know what the other's doing. It's kind of weird, okay? So she turned around and she tells Mr. Steele that they're going to call him and give him the date where for him to come back for them to address those motions. Okay. The first motion they're going to deal with is the bond motion. Okay. And then the next motion is the motion for it to be dismissed, which is the immunity one. Okay. And Mrs. Steele also basically stated to that there is some discovery that he is going to ask for it to be suppressed. There's some things. So there's a lot of stuff that has to happen to this case prior to any kind of trial. So, and Mr. Steele also reminded her that he has a lot of trials that he's doing. In fact, he has one trial which is all the way in Louisiana. And that trial, it's a federal trial. It's supposed to last like 7 months or something like that, he said. I think he said 7 months or seven. No, it was 7 months. So, and then he has a federal case here that's going to last about 2 months. And he has a lot of cases. And, I was having a conversation. He says he's have cases all over the world. So I was like, wow, all over the world. He says, yeah, he has a lot of cases, even overseas. I was like, wow, Mr. Steele is really like busy. So he said so Judge Williams did tell him that within a couple of weeks they should be coming back with some information on when his next court date is going to be. Now, on the way out in the hallway, now we have done with the courts thing. Mr. Steele was speaking, and I had asked him some questions and things like that. And one of the questions was about whether or not a plea deal was given. And he said, yeah, it was a plea deal was offered, and he declined the plea deal. And that plea deal was, I think, 10 years or something like that, and he declined it. So they are going to trial for this case, and unless they throw it out, they will be in trial, and hopefully it will fit in within his schedule for when, not interfering with the other stuff that he has. Right now, he's asking for his trial not to start until like around May, and hopefully it'll start May and then it'll be over it. But that's basically what happened in the courtroom today. As far as that, I did ask some questions about my interview, and he said for me to call him and we'll start the is Adam on this case with Steele? No, Adam is not on the case with Steele. No, Adam has a lot of cases that he's doing, and I'm supposed to be covering some of his cases too. So it's a lot. They've been very busy. I saw Bruce Harvey in the courtroom too today. He was in that same courtroom, and it was great to see all three of them together. All right, so let me go ahead on and put the link in. One of the reasons why I go to the courthouse, because I want to get the factual information and not made up stuff. Are the motions posted anyway? Yeah, I read the motions yesterday, Lee. I read the motion. Did you want to see the motion? I can show it on my screen. You wanted to see it? But if you watch my old live, I put the motions in there. Yes, Yak is waiting for McBurney. But I'm told that it is a possibility that he can make that decision without having to have a court date. All right, hold on a second, Lee. Hold on. As well as Whitaker. Yeah, they both could make a decision without even having a court date. So, but we'll see what happens with that. And they consolidating both to make it into one. And supposedly a plea offer. Remember, I told you every single one of them gives a plea offer. Every single one of the cases. It's just that people just don't want the plea offer. Can I look? Love your post. Okay, let me get it for you. Hold on a second, y'all. Yeah, let me tell you something. I am on a computer. I'm on an Apple computer, right? I've had my Apple for about 2 years, y'all. I still don't know how to use it. I still don't know how to use it. I'm so much like because this is my other computer here, right? And it's so old and it doesn't do anything anymore. And I'm like, in this Apple here, I'm like, so like, Jesus help me. So when I send stuff to my computer, I have to try to figure out how to find it. I have to find it. She said Apple's the way to go. No, it is not. No, it's not. Apple's not the way to go. Apple gets me so confused, y'all. Okay. I'm trying to go get that those paperwork for you. Hold on a second. Let me go figure out how to get up in here. Okay, hold on. Because normally I would just go up here and get the stuff that I downloaded, but no. Let's see. Hold on. Okay, there it is. Downloads. Okay, hold on. Hold on, y'all. Hold on. I think I found the motion. I did. I found both motions. Yes, I did. Hold on. Let me go get the other one. Hold on. There go the other one right here. I'm getting better at this getting stuff over here. Okay, that's that one. Okay. I got him. All right, here we go. I got to put my little watermark on here because I pay for my these motions. I pay for them. They're not free, and you know what I'm saying. I had to pay for these, so I got to put my little thing here. All right, here it goes. Here come the first one. This is the application petition for a bond. You see it? You guys see it? That is the petition. He did that on December 30th, 2024, right? So that is that first one. Okay, let me roll it up. I have to use Windows for gaming. It sucks. Apple sucks. Hold on a second. Let me go ahead and scroll it up for Lee. Hold on a second. I'm going to do that for Lee. All right, Lee. You see, this is the petition. Well, you know what? This is when it was Judge Bennett. Judge Bennett is no longer on the case. It's Judge William. Judge William got this case in January. Okay. So now you see Judge Bennett's name is on here. It says motion for a bond. And then Mr. Steele put it in there. He says the reason was because he deserved a bond, right? All right, there it is right there. Statutory right to pretrial bond to be granted. It's a statutory right, okay? So you see that? And she had not answered this. She had not. And you know what? Now that I look at this, they did have Judge Bennett's name on here, y'all. So we're going to give her a little bit of grace because it was the other judge it was addressed to, and maybe she didn't get it. Let's just give her a little grace on that one, okay? All right. And then she did mention the motion that was recently submitted for her was done on February 24th, and they was waiting for calendar time to put that one on a calendar. And that's why that one hasn't been put on the calendar, because that was done last week. 24th was last week. Okay. Did you want to see the other one, Lee? Did you want to see the other one? Let me know if you want to see the other one. This is especially for Lee, because Lee said she liked my, or she or he liked my my channel and my posts. So people that like me, I like them too. Okay, let me go get it for you. Hold on. All right. Okay, now remember the immunity that they've been talking about? That immunity is for him, not the immunity that these people trying to fake like he applied for. That's Jeffrey's immunity. No, this is for him. You see? All right. And that was done on the 25th. I said the 24th. No, it's the 25th he put this in, right? The 25th of February. And this is, look, you see how he put it to Judge Williams? You see? The other one was to Judge Bennett, and this one is to Judge Williams. Okay? So now come defendant Gregory King by and through undersigned counsel, and hereby files this motion for pretrial immunity in the above referenced case. In support of this motion for immunity, Mr. King shows as follows. Number one, Mr. King is innocent of all charges in the above referenced indictment. Number two, Mr. King hereby respectively requests that this honorable court schedule a pretrial immunity hearing to determine whether the above referenced bill of indictment must be dismissed and the above referenced case be barred from trial pursuant to the immunity statute. Ooh. We got to find out what the immunity statute codified is. We got let me take a look at this. Muse versus state. Let's go look at this. Let's look at that. I am not a lawyer or anything like that. I just like to get a full understanding. Even though if I read it, I still may not understand it. But let's go take a look. Let me Google that part and I'll see what's going on. Okay, let's see. All right, they have a case site for Muse versus state, and let me see what the basic understanding of this case. Okay. Let's see. Oh, this is his case. Oh my God. Steele picked the case that he won. Mr. Steele picked a case that he won. Oh, Lord, Mr. Steele is on the one. Look at this, y'all. He picked a case that he won. Listen. Muse versus the state, right? Brian Steele, the Brian Steele firm in Atlanta for appellant. Lord! Mr. Steele picked his own. Let me see what they would. Okay. That is awesome. That's awesome. Isn't it awesome? Because that means he knows the case. He knows he's going to end up winning on that because that's his own case. I tell you, man, Steele is the beast of the court system. Oh my God. This is great. Great. Okay, let's see what the outcome actually can, because we already know he won, right? Okay. Do y'all want to read? Okay, Brian Steele. Let's not read all of that stuff. Let's see. Appellant Beth Ann Muse was tried by the Walton County jury and convicted for murder and the unlawful possession of a firearm during the commission of a felony, both in connection with the fatal shooting of her husband, Mark Muse. At trial, appellant admitted that she killed Mark, but she argued that the killing was justified. Here's why. Now she appeals contending that she was denied the effective assistance of counsel. We see no error and affirm. They see no error and affirm. Hold on, y'all. Let's see what happened. Okay, hold on. Wait a minute. Hi. Okay, let's finish reading. The crimes were committed on January 2nd, 2009. Appellant was indicted on July 24th, 2009, and charged with malice murder, felony murder, aggravated assault, and unlawful possession of a firearm during the commission of a felony. Her trial commenced on October 18, 2011, and the jury returned its verdict 4 days later, finding appellant guilty of all counts. Appellant was sentenced for imprisonment for life for malice murder and imprisonment in a consecutive term of 5 years for unlawful possession of a firearm during commission of a felony. The verdict as to felony murder was vacated. Oh, that was vacated? Felony murder was vacated, y'all. Operation of law, Malcolm versus State, and the aggravated assault merged with the malice murder. Okay, that was merged with malice. Appellant timely filed a motion for a new trial on October 27, 2011, and she amended it on November 14, 2011, again on April 19, 2012, and yet again on May 23, 2012. The trial court denied her motion for a new trial November 28, 2012. Appellant timely filed a notice of appeal on November 30th, 2012, and the case was docket in this court on April 2013, term and argued on July 1st, 2013. View in light of most favorable to the verdict. The evidence shows that appellant learned in late 2008 that Mark was having an affair with a co-worker, y'all. At first, appellant said that she wanted to save their marriage and urged him to go to marital counseling. In December 2008, Mark agreed to counseling, although he also said that he wanted a permanent relationship with his lover. Lord have mercy. Wait a minute. Let me see if y'all listening. Hold on. I want to see if y'all listening to this. He wanted a permanent relationship with his lover. Okay, let's go back. Y'all, why are we reading this? This is juicy stuff, right? Okay, let's go back. Okay. He wanted a relationship with a permanent relationship with his lover. On December 26th, Mark told appellant that he was leaving her. The next day, appellant reported that she had found a burglar in her home. The old burglar routine and shoot her husband. So she said it was a burglar in the house. Oh, Jesus. Oh, my God. She said it was a burglar in the house and took him out. Oh, y'all, that's not funny. We're not laughing at him being dead. We just, okay. Woo, child, this is some juicy stuff, y'all. Let's go ahead and continue. Hold on. We gotta go back. Go back. Okay. Listen. The next day, appellant reported that she had found a burglar in the home that she and Mark shared. And Sergeant Joseph Broccoli of Walden County Sheriff Office responded to the report. Appellant told Sergeant Broccoli that the burglar fled when she saw him, and she gave description of the burglar that was consistent with description of a suspicious man whom her neighbor had reported in the area few weeks earlier. As he looked around the Muse home, Sergeant Broccoli observed that the master bedroom appeared to be ransacked, and he noticed that jewelry and firearm had been left behind in plain view. Ooh, she didn't work. She didn't do that one too well, y'all. Actually, Sergeant Broccoli was a corporal in December 2008, and he had been promoted to sergeant by the time of the trial. In this opinion, we referred to him as sergeant. In November, the neighbor had reported that a suspicious man had attempted to enter her garage and that he also walked across the property of the Muses. Appellant had knowledge of her neighbor reporting the suspicious man. On the morning of December 28th, Appellant drove herself to a hospital where she complained of dizziness, nausea, and lightheadedness. Appellant told the hospital staff that she suspected that her husband had given her a date rape drug. Lord, this woman, y'all. Wait a minute, y'all. This woman is too much. She said her husband gave her a date rape drug. Lord have mercy. Okay, hold on, y'all. Hold on. Let's go ahead and continue. Oh, according to a nurse, however, the symptoms that the appellant reported were not consistent with the ingestion of such a drug. Her symptoms instead were more of consistent with a virus. Also, on December 28th, after appellant returned home from the hospital, she called for Sergeant Broccoli, and he again responded to the Muse resident. There, appellant asked him about the circumstances in which one would be justified in shooting an intruder in self-defense. She premeditating this stuff, y'all. Sergeant Broccoli explained that if a person were in fear of her life, she could use firearm in self-defense and fire it until the 649 threat no longer was present. Appellant also asked how to fire a gun so as to kill someone. Yeah, we can't make this up. We cannot make this up. We cannot make this up at all. She is asking the sergeant this question. She's premeditating this. Oh my God. She's premeditating this before she actually. Oh my God. She calls the sergeant back to her house to ask him these questions. Listen to this. Sergeant explained that if she would fear, okay, we read that part, okay. Appellant also, okay, about killing someone. And she asked how to use a firearm in her home, including a 40 caliber handgun. In addition, appellant told Sergeant Broccoli about her impending divorce, that she feared losing her 2-year-old son to Mark in a divorce, that Mark acted funny when he did not take his medication, and that she feared Mark as well as other unnamed person. Okay, number 4. This is okay. This is a footnote. About her fear of her husband, a chiropractor who had treated appellant testified at trial that she had injuries consistent with domestic abuse. The chiropractor acknowledged, however, that her injuries also might have been caused by a fall, car crash, or other accident. And he admitted that appellant never said anything to him about abuse. The marriage counselor who counseled the Muses testified that appellant had said she previously been in an abusive relationship, but the counsel did not testify that the appellant reported that Mark had abused her. Appellant had pointed us to no evidence that we have found none, that she reported physical abuse by Mark to anyone prior to his death. After she was arrested, appellant claimed that Mark had abused his first wife and daughter, and both testified at trial and denied any abuse. Ooh, child. Mark spent New Year's in Atlanta hotel with his lover. On the afternoon of January 1st, he returned home. The next morning, around 3 a.m., appellant called 911 and Sergeant Broccoli again responded to the home, where he found appellant in the marital bedroom and Mark lying on the floor next to a spoon. Mark had substance 5 gunshot wounds, one of which was fatal. According to a crime scene investigator, Mark had been shot first in his chest, then fatally in his head, and then as he laid on the floor 3 times in the area of his groin. Oh my gosh, he was trying to shoot his ding ding and abdomen. Appellant told Sergeant Broccoli that she had shot Mark and had sexually assaulted her. Lord, now he raped her? Whoa. Okay, y'all. Get the likes up, y'all. Come on now. I'm giving you some juicy, juicy stuff here. Hit the like button. Hit the like button. They're gonna hit the like button and listen to it. Can y'all please hit the like button? Okay, yeah, y'all ready? How many likes do we got now? Are we getting the likes up? People, I want to finish reading this to you guys. How does this connect? How does this is what he put into the in the motion self-defense of property. This is self-defense. Well, it didn't work for her, but he's putting it for Gregory King. Okay. All right, y'all ready? Have they Lee, did you hit the like button? Lee Lucas, did you hit the like button? Instead of them hitting the like button, you know what they said? They decide to leave the room. You see how nasty some folks can be, y'all? But then they'll go into some thank you, Lee. And then they'll go to another content creator who tell lies and who they tell lies and give them clickbait stuff and they appreciate the lies. But that's okay, y'all. Let's go ahead on and let's go get the juicy stuff. All right, you ready? Listen to this. It gets better, y'all. She said that he okay, let's go back up. Because she said he sexually abused her. Hold on, y'all. We gotta go back up. It gets deep, okay. He had sexually assaulted her. Appellant was seated in the edge of the bed on which there were 2 firearms and 2 loaded magazines. About the alleged sexual assault, appellant initially told investigators that it occurred between 9:30 and 10 p.m. on January 1st, but she later said it was between 9 o'clock and midnight. Appellant explained that Mark had entered their bedroom and stood between her and the door. She said that she told him that she wanted to leave, but he would not let her. Appellant claimed that Mark then touched her breasts, removed her pants, and put his finger in her vagina and performed oral sex on her. Appellant added that she told Mark to stop, and he refused. She could not overpower him. She also said that Mark masturbated and eventually ejaculated into his hand. Appellant explained that she shot Mark when he returned to their bedroom several hours after the alleged assault. In her discussion with investigators, she did not claim to have seen a weapon in his hand. She also did not admit that Mark had been carrying a bottle of liquid hydrocone, which the appellant had been prescribed. Appellant had been prescribed, and which was found on the floor of the bedroom closet with blood on the label. The blood on the label matched the blood match taken from Mark. At trial, there was evidence on internet search by appellant in weeks before she shot Mark. Lord, hold on, y'all. Why is it these people, whenever they're about to commit a crime to somebody, they turn around, they search on the internet about that particular crime? Why search the internet? You giving yourself up. You telling on yourself. Why? Why search? It seems like every single body that commits or allegedly committed a crime or have been convicted of crime always search the internet for how to do that crime. Lord have mercy. What is wrong with these people? They better start watching these channels. And then if they're gonna do, it's like that show, How to Get Away with Murder. Remember that show? They need to start watching those shows and stop doing Google search on stuff. All right, let's go ahead on and finish reading this. Okay. At trial, there were evidence of internet searches by appellant in the weeks before she shot Mark. At first, she had searched for information that one might expect to be interest of someone trying to save a marriage. Then on December 26, when Mark said that he was leaving her, appellant began to search for information about divorce attorney and child custody law. On December 27, the day of appellant went to the hospital and asked Sergeant Broccoli about firearm use. She searched the internet on information about personal defense, laser sight for firearm, and date rape drugs. Lord. Oh my God. Based upon review of the entire record, we concluded that the evidence adduced at trial was sufficient to authorize a rational tier to fact to find beyond reasonable doubt that appellant was guilty of the crime of which she was convicted of, Jackson versus Virginia. Appellant claims that she was denied effective assistance of counsel and that the trial court therefore ought to have granted her motion for a new trial. To prevail on her claim of ineffective counsel, appellant must prove both that the performance of her lawyer was deficient and that she was prejudiced by this deficiency performed. Strickland versus Washington. To prove that the performance of a lawyer was deficient, appellant must show that her lawyer performed his duty at trial is an objectively unreasonable way. Considering all the circumstances and in the light of prevailing professional norm, and to prove that she was prejudiced by the performance of her lawyer, appellant must show a reasonable probability that for her counsel unprofessional error, the result of proceedings would have been different. A reasonable probability is the probability sufficient to undermine confidence in the outcome. Strickland and then Williams versus Taylor. To this burden, although not impossible to carry, is a heavy one. We concluded the appellant has failed to carry her burden. First, the appellant argues that her lawyer was ineffective when he failed to object to closure of the courtroom during voir dire. The trial court did not close the courtroom for the entirety of the voir dire. but it did so when the prospective juror would ask questions about certain sensitive subject, including their own experience with marital infidelity, sexual abuse, and domestic violence. The right of public trial is guaranteed by United States and Georgia's Constitution. Purvious versus state, and the right to extend to the voir dire to prospective juror in criminal cases, among other proceedings. Presley versus Georgia, State versus Brown. And it says, in some circumstances, however, the right to public trial may give away to the other rights or interests in such the defendant's right to a fair trial. And we have held before that it sometime may be permissible for court trial to close portion of voir dire to the public for the express purpose of expanding the odds of an impartial juror and thus a fair trial. Punctuation citation omitted. In this case, at the hearing, on the motion for a new trial, appellant trial lawyer testified that he did not object to closing of the courtroom for a limited part of the voir dire because he thought it would encourage prospective jurors to speak more candidly about their own experience with marital infidelity, sexual abuse, and domestic violence. And such candor would allow him to be more effectively assess the prospective juror and exercise the preemptory strikes. However, moreover, the lawyer said that he conferred with appellant about closing the courtroom for the part of the voir dire, and he did not recall her objecting to it. This court must indulge a strong presumption that the counsel conduct falls within the wide range of reasonable professional assistance. That is, the defendant must overcome the presumption that under the circumstances, the challenged action might be considered sound trial strategy. Strickland. We cannot say that it was unreasonable for the lawyer to think that closing the courtroom might facilitate his efforts in assessing the prospective juror and strike a favorable juror as possible. The appellant has failed, therefore, to overcome the strong presumption that the failure of her lawyer to object for the closing was reasonable trial strategy. Next, the appellant claimed that lawyer was ineffective counsel because he did not object to the prosecuting attorney at trial of offering evidence to testify. That appellant had given in a pretrial immunity hearing on her motion for a new trial. Her lawyer explained that he informed her at the immunity hearing that she did not have to testify, and he advised her that if she did testify, her words would be burned into the record. And when asked if she informed her of her testimony at the hearing might later be used against her, he responded in a manner of speaking, yes. Then he explained that although he might not recall the precise word he used, he had spoken to her, he did recall discussing with her whether it was wise for her to testify at the hearing. Given that she would be exposed to cross-examination, there would be a record of what she said. Eventually, both the lawyer and the appellant concluded, however, that she sought to testify at hearing, and she did. So she testified. So she messed up her own self, huh? At trial, her lawyer did not object to the prosecution attorney read her testimony for the immunity hearing, in part because the lawyer believed that such an objection would be meritless. But the lawyer also had strategic reason for not objecting. He explained, for instance, that the reading of her earlier testimony gave the jury an opportunity to hear the account of the appellant without subjecting her to the risk of cross-examination at trial. Moreover, her lawyer thought that the appellant had held up fairly well during the cross-examination in the immunity hearing that she testified. I mean, her testimony might out platable case for justification, and her lawyer believed that the reading of her testimony from the immunity hearing was especially helpful to the extent that she had in that testimony expanded upon her statement to the investigator. We cannot say that the lawyer's strategy for not objecting was unreasonable, and even if an objection at trial might had some merit, appellant has failed to overcome the strong presumption that her lawyer performed reasonably. All right. Okay, this is the last part. Last, appellant claims that her lawyer was ineffective because he did not realize at trial that the law enforcement officer had given inaccurate testimony about DNA, and as a result, he failed to object to that testimony or to rebut it. The officer in question testified that the absence of male DNA in the breast and libido swab sample taken from the appellant after Mark was shot. In the course of his testimony, the officer said that if saliva had been in the sample, DNA would have been detected. And he explained that DNA contains covers both the saliva and the DNA from semen. But at the hearing on the motion for a new trial, appellant presented uncontradicted evidence that DNA would not always be found in saliva. Appellant says that the inaccurate testimony by the officer at trial made it impossible for juries to believe her account of sexual assault involving oral sex, and her lawyer should have objected or rebutted the inaccurate testimony. He did not, apparently, because he did not understand the officer had testified inaccurately. Even if the failure of the lawyer be better understood whether DNA would be expected in saliva amount to deficient performance, appellant has failed to show that she was prejudiced as a result of such performance. Her own expert admitted on the motion for a new trial that the DNA might be found in saliva if the saliva were mixed with cells that from the mouth or elsewhere, and the record contained nothing about likelihood that DNA would be found in saliva transferred during oral sex, especially the sort of violent oral sex the appellant described. And in any event, the prosecution in this case did not build its case around disproving the contention that Mark performed oral sex on his wife. In fact, the prosecution did not even depend upon disproving the occurrence of the sexual assault. As the prosecuting attorney put it in closing argument, this case is not about appellant abuse. To the contrary, the prosecution attorney argues that even if Mark had assaulted appellant as she claimed, she still would not have been justified in shooting him several hours later. The prosecution attorney never argued that physical evidence, whether DNA, saliva, or bruising, was inconsistent with the sexual assault. Accordingly, we are unconvinced that the appellant has shown a reasonable probability that, but for her lawyer's failure to object to rebut the inaccurate testimony of the officer, the result of the proceeding would have been different. Strickland. For this reason, appellant has failed to carry her heavy burden to prove ineffective assistance of counsel. All right. All justice confirmed. So they confirm her conviction. I wonder why. Okay. There wasn't a good self-defense. Okay, Leah, you still here? Leah, you still here? I want to know if Lee was still here. If Lee wanted to Okay, so you want me to still continue to show you the what's the name? Motion? Okay, here we go. So that he used mute. Okay, he used that one, right? Reference a case barred from trial pursuant to the immune statute codified in OCGA. So we got to find out what this code is. OCGA 13 16 3. Let's go see what that one is. Okay, immunity from a person who's used forces. Okay, there it is right here. All right, here we go. Hold on. Okay, here it is. Here's the code right here. Here's the code. Code is 2024 Code of Georgia 16 is the crime offense, and it is 16. What was it? 16-3-1, right? And it's for code of defense, and then number 3 is defense of criminal prosecution, and then number 2 is justification and excuse. It says a person who uses a threats or forces in accordance to code section 16-3-20, because it's got all those numbers. It says shall be immune from criminal prosecution, therefore, unless in the use of deadly force, such person utilize a weapon, the carrying or possession of which is unlawful, such person under Part 2, Article 4, and Chapter 11 of this title. Let's see. It's immunity from prosecution. Okay. So that's the motion that's still put in. I thought it was going to be a win that Steele had, but I guess he put in a motion for something that he did already. Okay. All right, good people. So you guys. Oh, I was supposed to be finishing off that, right? Hold on a second. Hold on, Lee. Hold on. Let me finish it off. And then it says, Mr. King asserts the defense of self and others. So it says on or about February 12th, 2025, co-defendant Lindsay filed a motion for immunity from prosecution. Mr. King joins this motion. So you want to see what that motion that he filed on that one too? Lee, do you want to see the motion he filed on that one too? I aim to please, Lee. You let me know if you want it. Hey, SS. Okay, let's go ahead on. Let's go this. Okay. SS, I was looking for you the other day. All right, so let's do this final one. Let me get it for Lee. Hold on a second. Okay, here we go. All right, Lee, you ready? Here we go. You need to call me? Okay. All right, here we go. Here's the motion, y'all. This is immunity from prosecution motion that his co-defendant put in, and Mr. Steele adapted to it. Now, here's what they said. Motion for immunity from prosecution. Now comes a defendant in the above style case by and through his attorney and petition this court pursuant to OCGA 16-321, 16-323, 16-324, 16-324.2 to find his immune to this further prosecution because he was reasonably defending himself, property, and others against the alleged victim. Furthermore, defendant petitioned this court to hold a hearing on this issue at the soonest possible date so that if he is found to be immune, he is not subject to any further prosecution. See Boggs versus State. Explaining immunity language, OCGA. We need to go find out what Boggs did on that one. And because this issue must be decided prior to trial, Fair versus State. Defendant also petitioned this court to make factual finding and issue a final decision regarding defendant's immunity under a preponderance of the evidence standard with burden placed upon defendant. Byrne versus State. Defendant also asked that a hearing be transcribed. Finally, defendant does not waive his right to the affirmative defense of self-defense, defense of property, and defense of others. OCGA 16-3-21, 16-3-23, and 16-3-24 at trial. If a trial is necessary because the immunity issued address whether the state can continue to prosecute the case, it is auxiliary that to defendant's guilt and innocent at trial, which must be determined by a trial jury under a reasonable doubt standard. Bunn, and it gives a case law on that, and it's the 12th day of February 2025, respectively submitted. Marsha Mignot. All right. All right, that's it. Also, Miss Sylvia, can you get it? Huh? Can I get it, Mike? You can't hear me? You can't hear me? Oh, okay. I don't understand what M. Miller is talking about. All right. So let me take this thing off my face. Hold on. I'm good. Okay, Brooklyn. Everybody got it? Okay. Lee, you got it now? You got what they were trying to say? Lee, you got what they were trying to say? Hey, CBB Candace, how are you? Okay. You're welcome. So anybody else have a question? So that is what happened in court. We're waiting for another 2 weeks and another week or whenever it is. I will be looking at the calendar and bring you guys any 411 what happens. So I try to be as detailed as possible, giving you guys as elementary because I'm a lay person. and I like to give you layman's perspective of things. I don't know the law, and I all I can do is read. I can bring lawyers in here to answer questions, but as far as me knowing this stuff, nope, I don't know. I don't know. I don't know. So, anybody have any question? Y'all feel like coming up? Y'all feel like coming up today? Y'all feel like having a conversation with me? You're welcome, Lucas. Lee. Y'all feel like coming up with me and having a conversation, or y'all just too scared to come up here? Y'all punking out? Y'all punking out? Punking out on me? Are you guys punking out? There we go. There go the link. Hit that. Who's brave enough to hit the link? Hit that link. Hit the link. Are you are you guys brave enough to hit the link? Who's the brave one? Who's the brave soldier that's willing to come on out? Come on out, soldier. You at work? Oh, Lee, you can't come up. Oh. Oh. Can we cry? All right, Musa. Who's gonna come up? Come on up. Come on. Come on. Come on. Pew, pew, pew. Come on. Come on, Cletus. Come on. Come on. Come on. Y'all gonna make me act crazy in here. Could y'all get your butt up here now? Y'all scared of me. I noticed y'all all scared to come on up here. Okay, y'all. Here come Rachel. Your thing is not connecting, Rach. Rach, your thing is not connecting. It's not connecting. Put your head on your head, on your belly. This is my hell. There she go.
Hi.
Hey, Rachel. How are you?
I'm good. How are you?
I'm just peachy.
Just peachy.
In Georgia, we peaches here.
I know that's right. No, I just wanted to come up and say hi and show you that I was the brave one.
Oh, thank you for being brave, Rachel. These little chickens in the chat. These some chickens
Right?
in the chat.
I missed you all over the weekend. I was super busy, so.
Oh, so how was your weekend?
Busy.
Oh, okay. Busy with the
Yeah,
children?
just them and the husband and getting stuff prepped. We got storms coming in tomorrow, so we're
Storms? Don't say
experiencing
it.
high winds now.
Is it like snowstorms? That type of storm? Okay.
No, severe storms.
Oh my God. That means whatever you get, we get it over here later on.
Yeah, it's supposed to go over to the east side. Move to the
If it
east.
come from the west to the east, and whatever y'all usually get, we get it later on.
Yeah, well, hopefully it won't be as strong as it's supposed to be when it hits us. So,
Oh Lord Jesus. I just hope it don't be bad. So that
yeah,
means warm weather's coming soon then, right? Hopefully.
yeah, it's been in the 80s here, but today it dropped. I think it's like only 50 something today. So, yeah, it's pretty chilly.
Yeah.
So,
Well,
yeah.
you know what I want to put up? Okay. Today, Love was there's supposed to have been a trial starting for the individual that unalive a deputy, right? And there is, hold on a second, I'm gonna put it up you guys. Let me put it up. Hold on a second. I think they said in a 10-minute mark, you can hear Love talking. Hold on a second. Love is back on. Hold on. He said in 10 minutes marker. Okay, let me do 10 minutes. Hold on. Right here. Okay, let's see. And supposedly Love got on there. It was a Fagin versus Love. No, she's not gone. You know how fake news are, Shanika. Shanika, these people been giving fake news from day one. That's why you got to come to the courtroom. You know, you got to come to the courtroom. And I kept telling y'all, she's not gone. She's right there. But y'all want to believe the fake news.
Yeah, too many people go into other chats and believing what's being said.
Yep. But they believe it. They want the lies. And then when things comes out.
You said this case is about what? About somebody unaliving
A deputy.
Oh, wow.
Mm-hmm. They unalived the deputy and the person. It happened in 2022. I can go give you a little bit of history on that one.
Yeah, CMT says it might be closer to 11 minutes, but I gave you a minute. You're funny.
Mr. Brown, how are you?
I'm fine, Your Honor. How are you?
I am doing well. I see that you're here, and I'm a little concerned as to why, because you're not on the shorter list for today.
Well, I saw that Chocolate Pasta was on the calendar for today.
If you will just take a look at my calendar instructions, everybody's on 4-hour call unless I tell you otherwise. But I appreciate you coming, but you're not on for this week. Your case is not on.
Okay, thank you.
All
So
right.
he hasn't been brought over.
No, sir, he has not.
Okay.
All right.
Thank
Wait a minute, that was the courtroom I was in.
You too, thank you.
Wait a minute, that's the courtroom I was in, y'all.
So it's the same judge?
That's Williams. I didn't know that A and F came in after I left. Hold on.
It is 9:45, and you have that.
Have a good one. That'll be responsibility.
24 SC 006348-01, and I allow for some additional time for you all to have a conversation with you. I trust that you've done that. And so please tell me how you all wish to proceed accordingly.
Your Honor, Mr. Washington would waive his speedy trial demand if we could have a continuance so that we're able to properly review the outstanding evidence.
Okay, you're waiving the speedy trial demand, so that means you're going to get a notice of withdrawal in connection with that at some point before 5 o'clock today. This case will be continued to whenever I can fit it back in, okay? With that.
Sure, yes, Judge, thank you. The state would object to a continuance, and at least we should be able to proceed until that waiver is filed.
No, because I'm going to pick a jury right now. So you want to go ahead and file the waiver now?
I will do that.
Do it now, okay? And then I'm going to go ahead and call my next case. My next case was supposed to be Ricardo Talbert, but Mr. Regis is not here. I don't think you were in here when I made the announcement earlier, but I have no notice of conflict, from Mr. Aragus, saying he was going to report to Bibb County first. And so I trust that is what he's done. And so, but for his not being here, I would have called Ricardo Tolbert next, the record to reflect that. In light of the fact that I believe that what he was going to attend in Bibb County was a calendar call, and I have a trial. And so I'm not quite so sure that a calendar call beats out a trial. I need to sort of look at my rules on that, but I know that he was desirous of moving forward. And so we would have been. So that leaves the case involving the state and David King to be called next. And Ms. Fegan is in the gallery and ready to go with respect to that. Does he have clothing that you have? Do you give that clothing to Sergeant Harris? And let's go ahead and get him dressed out as soon as possible so we can get these jurors downstairs, okay?
Your Honor, could the court allow me, along with go grab the part that I
You
have?
should do that. And we're gonna get him dressed out and we're gonna go forward with that. And we should do that right now, okay? In the meantime, we'll get this, Stephen, filed in. I have to step off the bench, but please do not leave the courtroom until you all can let me know that it has been filed and accepted. I will call the clerk's office downstairs and make sure that they're ready to accept it, okay?
I heard love, right?
We can always tell her voice from afar.
Mm-hmm. You said closer to 10 o'clock? You said, let me move closer to 10 o'clock? Let, CNT?
Because it's not usually that.
Tonight.
It's not the same judge I was at. Because it just
She's sending it to me right now. I think Ms. Sarah's got it. Just take a look at it. Okay. Yeah. I see it. Thank you. Ms. Tomlinson, will you let the clerk's office know? We're good, Jay. I did. Thank you.
I'm telling you, it sounds like Judge Edmond.
Okay.
I thought it was Judge Williams, but Judge Williams' voice is a little bit different from that.
Is it Major Berry?
Captain Barry, yeah.
Captain Berry. Hi, Captain Berry. Good to see you again.
Good to see you. I think they went downstairs to get some air fresheners.
Yes. We're waiting for Mr. Kinney to come up next. Sure, that's fine. Okay, thank you.
I'm still here, but, yeah, I guess we need a couple minutes to get started. Do you need me to do anything, or do you need help carrying stuff?
Key, you said who's going to court? As far as
I don't know what to do the rest of my day now. The next 2 days, because that's just,
Will you call Miss
love.
Love and tell her to come on back? It's time. We gotta be able to go.
Yeah, sure, that's just, she told me about.
Your shoes are fabulous. They really are. Like,
Your
you saw them too? Yeah.
I like her stuff.
Nice, yeah. She's on her way back, but I would really like to go ahead and get him out, so we can go ahead and get him. Can you just sit at the table?
Your Honor, was Jasmine Jackson on the short list?
He's en route. Excellent. Thank you, Sergeant Phillips. Thank you.
who was that person? He said Sergeant who?
I didn't hear it, but hey, I got to step down. My husband just got home, but I'm going to be in the
Okay.
live, but I'm
Okay.
going to jump down. Okay, honey.
All right, hold on, y'all. Who did she say?
Good morning. Hello. Jenny. I'm excited to be here. So did you hear what happened? So the first was supposed to go out, they withdrew their speedy, and now we're up. This is live? Yeah. This is live? It's okay.
Hold on, I want to see who she said.
He's en route. Excellent. Thank you, Sergeant Phillips.
That's Mr. Brown.
Thank you.
You see Mr. Brown head?
Good morning. Hello. I'm excited to be here. So did you hear what happened? So the person is supposed to go out, they withdrew their speaking, and now we're up. This is live? Yeah. This is live. It's okay. What you have, you're right, or what you know.
Oh, well, my phone's stuck now. My phone dead. Yeah, my phone died. Yep, my phone died.
Yeah, that's okay. Just a good thing. No. Oh, because this now. Sometimes they do that, but I don't think Judge Lethbridge does that. So, we're waiting for the DA to come. Miss Paul's not yet. Hi. Yeah, she was on the first case. So what else do we know? We're waiting for the jury to come up. We should probably be done with today. So what happens is we actually send out that fight, and the jury will be ready. And they should be, okay? Then we have.
Sorry, y'all.
The jury will go in that box and we'll get the top door one by one. So that's when we decide. Not everybody here one by one. Yeah.
They take a mighty long time, CMT.
Excuse me? No. Yeah, no, it's not. It's not me. Okay.
And I hope you go with that. No, no.
Okay, please be seated, ladies and gentlemen. All right, we are gathered together here at 10:15 on March 3rd, 2025, in connection with the state of Georgia versus David Edward Kinney. Mr. Kinney is present in court, and good morning, Mr. Kinney. He is alongside his counsel, Ms. Nicole Fegan. And good morning to you again, Ms. Fegan. Good morning. The state is here by and through Deputy District Attorney, Ms. Adrienne Love, and good morning again to you, Ms. Love.
Good morning, Your Honor. Would the court allow, the state would like to ask for a scrutiny brief.
Okay, what is that?
Your Honor, there are items of evidence in this case that the state recently became aware have not been examined. And we, in short, are asking if the court would be inclined to allow us 1 week to have that to return. If not, I do want to address the court and make the court aware that the shell casings that were taken from the scene of the murder and the firearms that were found under the defendant's bed were sent to, well, our route to be tested this morning. That is the reason for the request. We do have witnesses that are out of state, and understanding that we were the third person on the court's shorter list, we were hoping that we would actually be able to get those people, get that evidence tested this week and possibly next week. But if that is not possible, the state understands that we'll proceed as directly instructed by the court.
My short list, my shorter list, do not necessarily list the cases in the order in which they are to be called. In fact, in my email says that. My published calendar says that. And so I think it's not prudent to rely on something that is contrary to what has been expressly stated by the court and habitually so. I recall us having a conversation, me, you, Ms. Love, Ms. Fegan, the last trial calendar. Ms. Fegan was ready to go at that time. And we had some discussions relative to this case being one that was what was focusing on trying. So I don't, I find this to be an untenable situation that I've been placed in relative to a case that like you all know, on Friday would be on the shorter list, and it's been on the short list for at least a week and a half prior to that, and then was looked at closely to being tried on the trial calendar in February. So I don't know,
instructions to parties in these cases. I had been on trial, the previous weekend was called in, doing the trial last week. And so the reason for that and all of this stemmed from that fact, not from anything of the nature of the court writings of the attorney.
Ms. Reed?
Your Honor, we would oppose any continuance.
All right, with respect to the discovery that has been suggested here by Ms. Love, you wish to move forward that outstanding?
Yes. Your Honor, in the event that GBI comes back, well, one, I don't expect any matches. Two, in the event that GBI comes back, I still feel comfortable that we can move forward.
So there's, so, Your Honor, my understanding from what Ms. Stevens just said is that there's no objection that she foresees as it relates to any testimony regarding matches, if there are some that occur.
That's what I think I heard. Am I?
You heard correct.
Okay. So, with that being the situation, looks like we can move forward.
Yeah, Your Honor, as we have been preparing for all of the cases, because, right, we don't know which ones will get called in.
Oh my God, lady.
Of investigators have been working religiously on making sure that we are ready.
But you're not ready.
There have been some challenges as it relates to the tools that they have at their disposal to secure our witnesses. And because of those challenges, you know, we're in an untenable situation ourselves. And if the court is not inclined, and I do understand the court's position regarding these cases, but if the court is unable to give us until next week, for the court
What?
to allow us to begin picking this jury this week, I believe we finish by Friday.
I don't know that.
Can you provide commentary about what? I'm listening to this. I can't provide it if I'm just listening to it. I don't know nothing about it right now.
It's Friday, and I have a specially set case set up for Monday.
Will the court give us until tomorrow to?
We'll pick a jury today, and then we can start the evidence tomorrow.
Yes, Your Honor, that is what we can get. Would the court be inclined to allow us to start picking a jury tomorrow?
Oh, no, we need to go ahead and pick this jury today. I have another case set up for Monday, and I need to leave enough time to finish this case before I can start the next case. And as I've said before, this case has been on the state's radar, perhaps not yours. I understand that you have changed in and out and all those things, but it's at least been on your radar since the February trial calendar. This whole saga started, I don't call it a saga, but the storyline, procedurally, forgive me, is that Ms. Fegan filed a speedy trial demand and put this on everybody's radar.
Dang, they turn it off? They turn it off, CMT? They turn it off? Oh, man. Oh, man. They turn it off. Yeah, they turn it off. Dang. Dang. I gotta reach out to let me reach out to Reagan. Let me reach out to her right now and say, hey, what case is that? Hold on, I'm calling Nicole.
Your call has been forwarded.
All right. I'm back. All right, guys. It is almost 2 hour mark. I'm about to get off this live. I will see you guys later. If I find out anything, I will give you guys back a call. I'll be back. I said give you guys back a call. I gotta make faces, y'all. I gotta make faces so I can be ready for whoever wants to use my memes. Let's take a look. Yeah, my glasses so what happened? It says Mimi. I think they're using the comment that Whitaker said in YSL case from IG comment she read out loud. What comment? Teo said, yes, no harm intended. Miss Sylvia knows what's up. What's up with what? Let me go back up. Let me go to what Teo's saying. Say, Sylvia, you're supposed to be in court live. Hey, you don't be using that word with me now, Toya. You done lost your mind using that N word with me. You better correct yourself. Don't be using that word with me. You know I don't use that word. You don't use that word with me. You done lost your everlasting mind. I'm going to give you some commentary. You ain't going to like it. I know you are out of order for that one. Out of order for using that kind of language in my chat. We don't do that. That word does not come out of my mouth at all. What was received? What are y'all talking about? What was said with Whitaker? What are y'all talking about? I'm confused. You said Teo didn't mean no harm. Using that word, that means a harm to me. I don't like using that word. Is a harm to me. That's a harm. But what are y'all talking about with Whitaker? I'm trying to figure out what he is saying when Whitaker said the N word in court when she was reading it in Instagram post. I don't care what Whitaker do. Sylvie don't like that word. Sylvie don't even use that word at all. Sylvia don't even use it at all. Let's see. All right. CMT, did you get enough? Did you get enough of the expressions? Did you get enough? CMT? Okay. All right. I'm about to go now. I'll see you guys later. If anything comes up, I will bring it back. I'll do a recap. Oh. What I'm going to do is I am going to upload the reading of the arrest warrant for those guys that unalived those teenagers. Okay. Those guys that unalived those teenagers, the one that I'm gonna go ahead and upload. It's in members only, but I'm gonna do some cutting and uploading it today. Okay. Sounds good, good people? All right. So I'm gonna upload that for you guys to see, because I don't think anybody ever posted what the arrest warrant was. All right. Thank you, Clifton. Where's my Lee? Lee, you gone? Lee, are you gone? Lee Lucas, are you gone? You're welcome, Clifton. Lee Lucas, you there? That's Lee was my my focal point today. Lee helped me to bring out some stuff that I didn't intend to bring it out. You're welcome. You guys have a great and wonderful day, okay? Be blessed and don't stress the mess. I need to give myself that advice. Be blessed and don't stress the mess. That's gonna be our little saying. Is there anything new on Hannah Cobb? I didn't even check. I haven't even checked. Let me go check and see. I don't think I checked anything. Let's see. Hold on a second. Let's see. I'm looking. Hold on a second, y'all. It says she's still in jail. Bond has not been set. Bond has not been set. Let's see. Let me show y'all. There she go right there. You see? Hannah Grace Cobb, current book. She's been in jail 7 days. Total bond not set. So that's where she's at right now. She's still in jail. Yeah, see? Okay. I'm trying to see the court thing. I was trying to see if I could find the online case information. I don't see anything put in there yet. Okay, y'all. Let's see if another one's in here. Hold on a second. They don't stream their courts anymore. All right, so I don't see anything for that court at all. I don't really see anything for All right, guys, I'm about to go. I will see you guys. Let's see something. Hold on. The schedule for domestic duty, Augusta Drug Court Program. Okay, my good people, I am about to get off this live and I will see you guys later. You feeling okay? Okay. All right, guys, see you later. May the Lord watch between me and thee while we're absent one from another. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. show. Every click and comment makes us grow. Minds in check, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mars in check, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click